Be seated, please. Court calls second case, Public Utility Commission of Texas versus City of Denton and Denton Municipal Electric. Who's present for the appellate?
Jordan Krause on behalf of the Public Utility Commission.
And I see 15 and 15 minutes. What's that about?
Well, in the court's letter, we were each side is given 30 minutes. Because we're cross appellants. So
who did that? Did you all do that? That's all right. All right. Yes, because you've got to respond to this. Okay. So it's going to be 15 and then 20 and then another 15 and then 10, you anticipate?
Just like a tennis match, Your
Honor. Okay. All right. And for the
Joe De La Fuente for Denton Municipal Electric and my partner Jamie Moulton at the
great. All right, Mr. Pratt, you may proceed.
may it please the court. So I'll just be addressing the PUC's appellant issue in this first 15 minutes, which is the debt service coverage ratio. And I'll address the general fund transfer issue in my second 15 minutes. But first, I did want to provide a little context. This final order set the rates that Denton can charge all users of the ERCOT grid to compensate Denton for its portion of the grid. And the grid is the high voltage lines, substations, and all the infrastructure for wholesale transmission.
And how did I didn't if there was a map, I missed it. You know, what has to run through Denton to get to other places?
I believe Denton's portion of the grid is just within its municipal limits, and it's connected to the grid, other portions of the grid outside of Denton. I don't believe Denton has one.
I thought the deal was it's charging transmission to people for use of its transmission lines. So, and that the argument is that if that's unreasonably high, you're overcharging everybody that's got to pass through there.
Well, the way electricity transmission works is it's not like a point A to point B.
Not like a toll road.
Yeah, it's kind of just the electric grid is charged, so electricity gets put onto the grid. So electric rates are set on the postage stamp method. So everybody is charged transmission rate, and every electric provider or transmission provider receives a portion of that postage stamp of the transmission rates.
Thank you.
Yeah, of course, Your Honor. So these rates that are transmission rates are then passed on to all ERCOT ratepayers, which is about 90% of the state. And Denton voluntarily chose to interconnect its transmission facilities to the ERCOT grid, and this brought its transmission rates under the jurisdiction of the commission. So while Denton sets the retail rates that it charges its own residents, the commission sets the transmission rates that it charges everyone else in ERCOT. So there are two components of Denton's rates at issue here. The reasonable rate of return, which is the debt service coverage ratio, and its reasonable and necessary operating expenses, which is the general fund transfer issue. The district court erred in reversing the provision in the commission's final order, setting the debt service coverage ratio. Substantial evidence supports the commission's conclusion under both the old and the modified rate filing package. The presumption in the old rate filing package that a ratio of 1.5 was reasonable was rebutted by evidence in the record. The Office of Public Utility Counsel, which represents small and residential consumers, they provided expert testimony finding that the maximum ratio that would be reasonable for Denton was 1.42. So that evidence rebutted the presumption in the old rate filing package.
It seemed to me, it was a little, candidly, for someone that doesn't do PUC work all the time, it's a little hard to follow in some ways. The RFP, it seemed, my understanding was it could be modified if it was truly just a instruction manual on how to submit your filing. But what we got here, it seems to me, is the elimination of a presumption for evidence. Why isn't that either one of two things, either significant under their argument, or why isn't that a rule?
Well, so the rate filing package, it's a 38-page document. And it contains all the requirements that utilities are supposed to, with the documents and information they're supposed to file in their application. And it contains instructions and guidelines on how that application is processed. So,
What about the presumption though? Like that's what I guess has us a little bit concerned.
yes, Your Honor. So the presumption was not a significant change because it didn't change any of the filing requirements or any of the documents or information that must be submitted in a transmission application. The presumption was instructions on how the commission would weigh the evidence that is in the application, so not what they needed to file. So it didn't change the ratios that they were allowed to request. They can request any ratio, and the commission will weigh the evidence. So the modification didn't change what ratios they're able to request, and it didn't limit what they're able to request or what they're able to receive. It was simply about the commission, how it weighed the evidence that is in the utilities application.
But they make it, they put a little bit of a finer point in their briefing that it sort of does change the ratio because the presumption is just a, I don't know if the word's additive, but yeah, I think you know what I mean.
Yeah.
It's an addition to whatever their evidence shows the rate should be. So isn't that a change in the very presentation of your evidence? If you're coming in thinking, here's the evidence we're going to present, and we got a presumption that's going to add 0.25 to that. I mean, how isn't that a significant change?
Well, it was a rebuttable presumption, so they weren't entitled to additional coverage simply because they requested it. And so it wasn't vested, they didn't receive this just simply by requesting it.
Right, and I'm not wanting to build into my question that it's vested. I think that's a whole nother issue in a way. But still, it's a presumption, and a presumption applies unless it's rebutted. So taking away a presumption, again, why isn't that significant?
Well, it was not significant because they may still be able to receive an additional 0.25 even on the basis of the information they file in their application without any, just on what they're required to file.
So would the presumption have been rebutted here based on the evidence that was put forth?
Yes, so that's it. It doesn't matter if the presumption was significant or not, because the evidence in the record rebutted the presumption if the commission had applied the old rate filing package rather than the modified rate filing package.
See, that's what I don't understand, because okay, if you're coming in with evidence and you have evidence that says it's 1.5. I think the position you're taking is, well, there's no evidence that would have been 1.75. But under the old RFP, if you presented evidence of 1.5, there was a presumption that got you to 1.75. Am I understanding that right?
I'll go over the debt service coverage ratio just and also lay out the evidence on how this was rebutted. So the way the rate of return is calculated under the debt service coverage method is it's based on their actual debt obligations and a reasonable coverage ratio. So the reasonable coverage ratio is the amount above their debt obligations. So under the ratio the commission applied here, the 1.25, that fully covers Denton's debt obligations and provides 25% of those obligations as profits. So this 25% is like the icing on the cake above their debt obligations and all their operating expenses. So using this ratio, they calculated a rate of return of 6.21%. But so yeah, the Denton's bonds all provide for a ratio of 1.25. That's what the bonds require Denton to maintain. And so the presumption in the rate filing package was an additional 0.25 on top of the ratio in the bonds. So Denton, the most Denton could have received under the presumption was 1.5. But Denton did not request a ratio of 1.5. It requested a ratio of 1.75. based on its city policy and an incorrect reading of the presumption. Their argument is that the presumption applies to any request of municipal utility. So if it requests a rate or a ratio, it just adds that on. But the commission has never applied the presumption in that way, and that's contrary to the plain language of the rate filing package. So the ratio only applied to the ratio in the bonds. The most that Denton could have received under that presumption was 1.5. But so Denton's request was unreasonable. PUC, OPUC, and Texas Industrial Energy Consumers all argued it was unreasonable and provided evidence demonstrating that it was unreasonable. PUC staff witness said that under no circumstances would Denton receive a ratio of 1.75. This was a very large amount. It was 75% of its debt obligations as profits, as 3 layers of icing on the cake above its actual debt obligations and its operating expenses. And OPUC's witness explained that this is a multiplier, so the ratio multiplies their debt. And Denton has significant levels of debt. So any incremental increase of the ratio substantially increased the rate of return that Denton would receive and the burden that would impose on the ratepayers. So the commission staff's witness reviewed Denton's application and all the information submitted by Denton and found that there was no reason, no basis in its financial data to raise the ratio above the ratio in the bonds. And he concluded that the ratio in the bonds provided Denton with a reasonable rate of return.
So it's not correct then that if the debt ratio in the bonds was 1.25 and they came in with that evidence, and let's say the commission agreed, but that's correct, 1.25. You're saying the presumption doesn't presume that you add 0.25 to that?
The presumption under the old rate filing package applied to the ratio in the bonds. So the way it was worded was like a baseline. A utility can request the ratio in the bonds and an additional 0.25, and that would be presumed reasonable.
Okay.
So a utility would request, if its bond said 1.25, it could request 1.5, and it would be presumed reasonable, which is rebuttable. So the other parties could challenge that, which is what happened here.
Right.
His OPUC's witness provided testimony showing that a ratio of 1.42 would be the maximum ratio that would be reasonable for Denton.
And was that 1.42 based on the debt under the bond, or was that adding in the 0.25 as well? That's what I really wasn't clear on.
No, that was the total rate, so 1.42. So OPUC's witness found that the ratio in the bonds was reasonable and it would have provided Denton with a reasonable rate of return, but he acknowledged there could be a range of reasonableness. So he analyzed other utilities that had recently completed rate applications at the commission and the rates of return that they received. And that was during the time frame of Denton's application, so the most recent rate orders. And based on those rate orders, he concluded that the maximum ratio that Denton could receive would be a ratio of 1.42. But he did say the ratio in the bonds was reasonable. Also, he was just providing this range.
Mhm.
So that evidence rebutted the presumption in the old rate filing package that a ratio of 1.5 would be reasonable. So the commission's conclusion to set Denton's ratio at the ratio in the bonds of 1.25 is supported by substantial evidence under both the old and the modified
So
rate.
the burden stops doing any work once there's evidence on the other side.
Correct. So a burden just operates in the absence of evidence, but once contrary evidence is introduced to the record, the presumption falls
When
away.
you say burden, you're saying, do you mean
Presumption.
presumption?
Burden of production.
Correct, the burden. So yeah, so the presumption is if there's no evidence in the record, the presumption presumed that would be reasonable, but once,
One of those shifting burden things, so it's.
yes,
You
correct.
gotta start, and if you start, then the other side's gotta come back with something. If they don't do anything,
Correct.
there's no dispute.
Yeah, correct, Your Honor.
Just one quick question. If we were concerned that the modification to the RFP was significant, would that mean that Denton Electric prevails, or would it then have to go back, or what? Hypothetically, how would that play out?
It would be remanded to the commission
Mhm.
to apply the old rate filing package.
Mhm.
But substantial evidence in the record supports that the commission's
So it would be
conclusion
based on
would
the same record.
it would be, yeah, the same record. So
But if that's the case, then why change it?
change the, so they modified the rate filing package because utilities were misinterpreting this presumption. When it happened, what occurred during that proceeding was the presumption was rebutted by evidence in that record when they made this modification, but the utility was arguing it was entitled to that additional coverage because of this language in the rate filing package. So the commission felt that this language was confusing and unnecessary because in a rate proceeding, the burden of proof is always on the utility to support its rate request and its application. So this burden had kind of muddied the waters here, and utilities were arguing that they were entitled to this additional 0.25 coverage. But it was a rebuttable presumption, so it just put it in the first instance. I see I'm out of time. So it was on the ratepayers. They could rebut it and go back to. So that's how it would operate. But now they can still request any ratio. This presumption is just this presumption language is just not in the rate filing package. So we request that the court affirm the final order in full. Thank you.
Thank you, Mr. Pratt. Mr. De La Fuente.
May it please the court. Some of the good advice my parents gave me when I was young, there's a good bit of it. Don't run around with bad people, because once you do that, once you make that first bad decision, then bad things follow from it. And really, this case is a whole lot of that. It starts bad and it gets worse. When you do something for the wrong reason, you go outside your authority and outside the law, then you're going to end up doing more that's outside the law. And honestly, I think if y'all really look at this case, this is not kind of your garden variety administrative appeal case. This is more of an ultra virus case, because it started from an inception of the PUC jumping the fence that the legislature put around it and acting outside that authority. And honestly, it's kind of the recipe. If you wanted to write a recipe for an unrestrained administrative state, that's how you'd get there.
You're saying on the basis of them deciding that your client had
Over-earned is the magic word.
they had over-earned, that tainted everything beyond it. Why wouldn't PUC, I'm not saying they could use it in their findings, but understand that, but I'm saying why couldn't, or why isn't it the charge, almost, I hate to say an implied charge for an agency, but if they think a utility is over-earning, don't they actually just have a duty to hear evidence and reset the rate?
100%, Your Honor. But I need to tell you, there's over-earning, and then there's over-earning. And I use those nice little air quotes because everybody loves those.
That's like a very clear line.
Well, one of them's real, and one of them's as imaginary as a leprechaun. Over-earning that the PUC has absolute authority to enforce against is you get a rate order, and it says, I'll simplify, it says you can earn $1 million a year. And we send in reports to the PUC showing what we're earning. And if we're earning $1.1 million a year, the PUC will call you in and say, you are over-earning. What the PUC can't do is set a rate that says you earn $1 million a year, and we follow it, and we earn $1 million a year, and we earn $1 million a year the next year. And then call us in and say we are over-earning, when all we have done, what we have done is what we're required to do. Follow the law and follow their prior judgment. So when the PUC uses the leprechaun over-earning, they've made something up that results in a collateral attack by the commission on its own prior judgment.
Now, was that a finding? Was that evidence? Or was that just one of the witnesses' impressions? Was it in the past you'd over earned, but they didn't actually base 1.42 on amounts in past years that were over earned, or did they? Missing that?
Uh, Your Honor, this is straight from testimony. Denton would not be justified in receiving a DSC ratio above 1.25x because based on its prolonged over-earning.
But is there any finding that says they relied on that particular testimony?
All the testimony in support of a rate below 1.5 included as reasoning for that an express statement that because of over-earning, this is the number. In other words, there's no evidence of a rate below 1.5 that is not tainted by testimony that that rate should be lower because of
I
over-earning.
would be a bit concerned as a court to say, I mean, that's usually not the way evidence works. It's not usually like you let in one little thing incorrectly and it taints the entire proceeding. I mean, that would seem to be asking us to find something that courts in these administrative cases don't typically find.
The commission said the reason that it was bringing us in was to investigate our over-earning. In other words, the reason for this docket, as stated by the commission, was leprechaun over-earning.
So if we were to write an opinion, it would say that because you were called in for the wrong reason, everything that follows after that is.
We were called in for the wrong reason. The entire case put on referred to that wrong reason repeatedly. And frankly, the commission's briefing at the Travis County Court on that admin appeal below and here repeatedly says over-earning, that the city DME has tacitly admitted they were over-earning when we came in and filed our new case. By the way, it's important. The old rate under the old valid final judgment was set when we were on a cash method. We filed the new rate case using the debt service method, which resulted in a lower return, but there's no admission of over-earning there. But yes, Your Honor, I would put it to you that if the commission said the reason I'm calling you in is because I don't like the religious creed of the majority of your ratepayers, you don't unring that bell.
Well, yeah, but that's a constitutionally protected reason. I mean, over-earning is not protected under the First Amendment, right?
So there's the constitutional protections that are a fence that keep you from going inside that fence and hurting me. You can't hurt me because of my religious creed. But administrative agencies live inside a fence, and they can only do those things inside that fence.
So I am concerned about the change of the presumption. Can you answer the same question we put to opposing counsel? So at the point that there's evidence, what work is the presumption doing at that stage?
So, and Justice Field asked the right question. The evidence was as to you have a base percentage debt service coverage ratio, and then you had, under the valid rate filing package in place, a presumption on top of that. All of the evidence and discussion was as to that base. There was no rebuttal of the additor qua additor. There's, as far as I can tell, no evidence in the record of, and you don't get the 0.25% because you're not appropriately entitled to it, et cetera. All the evidence was you've asked for a base of 1.5. You're not entitled to that. 1.42 we think is good, 1.25 we think is good, both of which literally say right afterwards, because you were over-earning. And I don't think you can forget that. But no, there was no rebuttal of the additor or the additional presumption.
How does that work in practice? I mean, how do you ever have a rebuttal of an additor? It doesn't seem clear to me how you even do that.
Flat out, you say it's as Justice Brister pointed out, it's a presumption, and then rebutting the presumption gets you to that burden of production on the other side. There has to be something that flags you that you've rebutted the presumption of the adder, and something as simple as, in this case, the adder should not apply because something like that. That's what I'd be doing the word search for in the testimony. Wouldn't find it here. And I think it's also again, it's not just, y'all asked about the significant, what was it significant when they changed the DSCR? And of course, it is. I mean, the language that the commission used from the dais and talking about it said the presumption was a huge amount on extraordinary rate burden. We need to provide clear instructions that an MOU's rate of return needs to be supported by evidence in the application, which they can amend their rules in their rate filing package to do that. But under their own rules, if it's a substantial change, they have to publish it in the Texas Register. And under state law, you have to provide notice. I mean, I'm here with my utility law partners. These people follow those meetings and pay attention to rule changes like a hawk. There's no way you would have known this was going to happen. Never on any public meeting agenda, never published in the Texas Register, nothing. It showed up after the fact, just in the books. So if you're going to make that sort of change, and it is going to have a significant and substantial effect, in this case, it's an $8 million effect on one MOU. There are 72 municipally owned utilities in the state of Texas, 4.1 million customers. If they're going to be subject to this, which you asked, also, is it something that's significant and has the force of rule? And I don't have the exact record sites in front of me, but before the commission, the staff argued, oh no, you got to follow the rate filing package. It has the force of a rule. And they're right. I mean, had we filed something that didn't comply with the rate filing package, they'd have been all over us to enforce it. We actually had a dispute over whether the rate filing package required a depreciation study, for example. That went back and forth at the commission.
Could you respond to the point that the PUC makes that really, because this doesn't require notice and comment, it's just notice and you had notice, and so there's no harm, no foul?
Both because, again, as I mentioned, it does require notice and comment if it's substantial. That's the PUC internal rule about if we're doing something that's substantial, we got to have the notice and comment.
Yeah, but I mean, I guess their argument, if it's insubstantial, is that what then?
If it's insubstantial, then, I mean, now we get back to, don't make bad choices because you end up doing bad things.
Yeah.
If it's insubstantial, well, all they've talked themselves out of is the ticket for running the stop sign. They haven't talked themselves out of the ticket for speeding. Because any change that is going to be made like this by the commission at an open meeting, which it unquestionably was, requires compliance with the Open Meetings Act. And as y'all know from 2001, 174, there are multiple bases on an admin appeal to overturn, and substantial evidence. Look, we all know it's not a super high bar. Jumping the fence and acting outside your authority and violating other law, and that's the old CLCND Oysters case, violating other law is outside your authority. It is ultra virus. And that's why I said at the beginning, putting on your ultra virus glasses are important here. Because if an administrative agency can just change its rules mid-game without telling anyone about it, well, then there are no rules.
And then let's assume that your argument's correct for a moment. How does that affect substantial rights? It seems to me, seems to me it's an uphill battle to say it's a vested right. So how do you get there on a substantial right being affected?
Well, it's kind of interesting to have state agencies arguing that. I mean, the rate filing package has the force of a rule, and rules have the force of law. And they have a real effect on the entity here, whether you're removing an actual evidentiary presumption or not, that has an unquestioned $8 million effect on the entity. Your Honor used the right terms earlier in talking about the fact that it is an evidentiary change. If I brought a breach of contract case and after the case, y'all told me there was a magical fifth element for breach of contract that you got to prove somebody was wearing a purple hat, well, I think that would be an infringement on my rights. I don't know what case to present. If you change the burden.
The element of the claim.
So you're saying that the change in the amount itself is a substantial right being violated.
I mean,
I'm not saying.
I think when the commissioners say from the dais, which was, by the way, the entire basis for this rule change, is that it's a huge amount, an extraordinary rate burden, and it must be supported by evidence in the application. You're stating the evidentiary standard to establish that to establish the right to this. I mean, if they want to change that and remove the burden, remove the presumption, they can, it's their rules. But the fair notice of that, when it has this material in effect, yeah,
Not, so I guess, are we not under 2001-038, you know, where you challenge improperly promulgated rule? Are we not there because of the statute using this alternative standard of significant change and notice?
not
It's
necessarily.
unusual.
It is unusual, and I mean, part of the reason we're not challenging the rule change, and this is an important one, there wasn't one. If you're gonna change a rule and you're gonna do it in an open meeting, you notice it. You actually provide public notice of it.
I see. So you're, and I didn't catch that the first time. You're saying because they violated TOMA, therefore the rule change itself is void from the outset.
It is. It is. I mean, fundamentally that, and again, once you've decided to do, they've decided they wanted to collaterally attack their old decision. The only way to do that is to put your thumb on the scale in a new case. And once you decide to put your thumb on the scale, then you're going to do things that run outside the law. It happens.
It's odd procedurally because let's just say you're correct again. Let's go down this line. PUC in their minds, they've changed rules, so why would they rebut the presumption?
This is how you end up in the fantasy world. They don't need to rebut the presumption. We don't need to address the rebuttal of the presumption because we're operating in two different worlds.
Because there is no presumption, they believe, and yet you're thinking there is, and
Misunderstandings are how these things happen here. And you create the misunderstanding when you start from the wrong point, but you end up there when you go outside the law. And honestly, we are also cross appellant. We are also appealing the denial of the general fund transfer component. We asked for a general fund transfer of 11%. And by the way, state law rather plainly allows the city to set the general fund transfer amount for any purpose. And in this case,
but does that mean though PUC has to give you the full amount the city sets?
nope, does not.
Because it seemed to me in the briefing, you know, you were talking about that, but yet I don't see that them saying the city can't do that. They're just saying we're not paying.
It's reasoning. It's reasoning, Your Honor. And this is where you do get into the overlap in this Venn diagram gets you into substantial evidence problems too. So no one is saying in the San Antonio Independent School District case we cited, which talked about general fund transfers and how cities get to do this. The point is the city gets to decide without question, has exclusive, and you can't step on it, jurisdiction, what the purpose is. City could have set this for library fund and road repairs. It doesn't matter. The PUC can consider the reasonableness of the amount. There is no discussion of the reasonableness of the amount, particularly a discussion that would support a finding of 0 for this component. There's no evidence for a 0 of this component. Every piece of evidence is at something greater than 0.
My understanding was, maybe I misunderstood this. They're saying you're double dipping. You own the utilities, so you get a rate of return on whatever the utility makes. And then the city wants another rate of return on what the utilities making. That's double dipping, isn't it?
And Your Honor just talked about a purpose. And that's where the PUC went out of bounds again. 1502.059 allows the city to transfer for any purpose. It could have been, it didn't matter what we called it. So what it was called is a red herring. The PUC doesn't get to examine and say you don't get it because of the purpose. Because if they don't like that we called it ROI, they could also say, and you know what, using it for road repair, we don't think that's a valid purpose either. Because remember, they actually came up not with a negative, you can't use it for that. What they came up with was a new standard that says you must prove that it's directly tied to transmission. So what that means is we couldn't have transferred by that standard if it was for roads or libraries or firehouses or anything else.
Then under your logic, then how would PUC ever reduce the amount city charge?
By doing a reasonableness of the amount, not the purpose. a reasonableness of the amount analysis. And at that point, you'd be looking at, well, we cited multiple cases where GFTs are approved from, 7.5% to 14% to this
But
at the other.
if they decided on the base rate plus, whatever added here, that's a reasonable amount and the city tacks on more for any reason, even if it's for road repair, or whatever else, isn't that by definition an unreasonable amount?
If it's number-based, they can make the decision. If it's purpose-based, they can't. And the problem is the entire case litigated and the evidence was purpose-based. All the number-based evidence is greater than 0 over the original 5% franchise.
All the number-based evidence was 1.42.
But you could never have a purpose-based inquiry here, like if the city decided we needed this to give our mayor a Lamborghini, then they can only fight about numbers.
Correct. Yes, Your Honor. 1502.059 uses words for any purpose. It does. Now, could then someone sue the city for ultra-virus transfer of funds to buy the mayor a Lamborghini, et cetera, et cetera? They could. But this is about staying in your lane.
I can see that, and I can see that you don't want the PUC deciding how cities should spend their money, what their budget should be, and that's the idea. But if your staff is telling you 1.42 covers their debt service, gives them a return on investment, and then why isn't anything over 1.42, which a 6% add-on for any purpose would be, why isn't that some evidence to support, substantial evidence, I should say? By the way, what's the difference in some evidence and substantial evidence? Some evidence, as I understand it, it's got to be enough for a jury, which I suppose could be 1%, 10%. Substantial evidence, that sounds like it's got to be 30. You can't do that. There's no such difference, is there?
Your Honor, I tried to write my my law school litigation guide note on this subject, and I kind of spun out because you're asking a great question. That was 30 years ago, and I don't know if anybody's
Maybe
really
the Texas Supreme Court could answer.
nailed it down
Yeah,
perfectly.
they just believed in City of Keller versus Wilson. It would be, it's like the universe, the theory of the universe. It covers everything.
Your Honor, I'm over my time, but I did want to kind of answer the initial question you had, and I think there's a challenge here, and I'm going to ask you to back up a little bit. I think you're conflating two things. The 1.42 is about the debt service coverage ratio component of the overall rate. The general fund transfer is an expense. It's a line item that goes into the rate.
Okay,
And so those are two separate questions.
all right.
Um,
Thank you.
Look, it's
You'll get you got another 10 minutes.
I do, and I will do my best to answer the questions when we come back.
Thank you.
Stay tuned.
Mr. Pratt?
So I need to address a few points right off the bat here. It's just simply untrue that all the witness testimony, all of the witnesses based their conclusions on this over-earning or Denton's past rates. That was one commission witness that talked about Denton's prior rates as one final concluding remark or an additional reasoning because of Denton's prior rates. So all of the actions here, all of the conclusions were based on Denton's bonds themselves, which require that ratio and analysis of Denton's financial information. So, and the theme running throughout this is that Denton is being punished, but as was pointed out by your honors, there's nothing in the final order basing any of these conclusions on Denton's prior rates or any punishment. And it's the final order that's under review, not speculation about personal feelings or motivations of commissioners. And this, because Denton also seemed to argue that it should have never even been required to file this rate application because this over-earning concept. So just to get, this is about the background of how this application was filed, how this proceeding began. The idea about the definition of over-earning or about whether Denton was overcharging on what its prior authorized rates were is not the issue here. The issue is that Denton's prior rates were no longer just and reasonable. So the commission had to call Denton in to adjust its rates. And the reason for that is rates are based on a test year, which is a snapshot of a utility's finances and operating expenses during that test year. Denton's prior rates were based on a test year of 2003 and Denton's finances and operations in 2003. And there was a 20-year time span, or about 20 years before this application was filed, where Denton's operating structure and finances changed significantly. It expanded by nearly 16 times. And so when it was still operating under this test year of 2003, well, its real actual operating expenses were no longer reflected in what that test year was. So this was resulting in unreasonable rates to Denton. It had a relatively small invested capital in 2003, so the commission had granted it a larger rate of return on the small capital, but its invested capital had expanded 16 times. So now that large rate of return was applying to a very large rate base, resulting in large returns. So this is entirely within the commission's authority. It reviews rates and reviews earning reports every year. Utilities are required to file these so the commission can determine whether their rates continue to be just and reasonable. So once Denton filed this application, that's all the commission was doing, was determining what are Denton's just and reasonable rates based on its current operating structure and finances. And nothing in the final order, none of its conclusions are based on the prior rates here. So that the one witness testimony did bring that up. The commission did not adopt that. It was a staff testimony, a staff witness testimony, and they don't speak for the commission. The commission can accept part of a testimony and reject the rest of the testimony. So
Could you just assume for me for a second, let's just put aside that issue. If the RFP change on the presumption was significant as a term of art, then what is the outcome here? What happens?
well, the outcome is it's remanded to the commission, and the old rate filing package would need to apply based on the evidence in the record. But as I pointed out, that was rebutted, but Denton argues it was not rebutted because they did not use the magic words, we are rebutting this adder. But evidence rebuts the presumption. The presumption was that 1.5 was reasonable, 0.25 on top of the ratio in the bonds. The evidence in the record was that the maximum ratio that would be reasonable was 1.42. So the witness didn't need to say, and by the way, this is rebutting that the 0.25 on the bonds.
Are you saying that hypothetically, a utility comes in and let's just say they approve 1.42? Are you saying under the prior RFP, there would not necessarily be a 0.25 addition unless there was further evidence? Let me back up. That's a very good. All right. Are you saying that normally someone proved up, let's just say the only number that came up at all was 1.42 on both sides? Let's just make it easy. Are you saying that normally there would not be 0.25 added to that?
The 0.25 only applied to the ratio in the bonds. So it's whatever the utilities bonds state. So the utilities bonds state that they are required to maintain this amount of debt ratio coverage to provide a sufficient return. So that's what the bond, whoever issues the bonds, so that's what the debt requires, a ratio. So whatever the ratio that the bonds themselves states, an additional 0.25 on top of that would be presumed reasonable. And I just need to point out again that Denton did not request the ratio in its bonds. It requested a much higher ratio of it requested based on a city policy and then added the presumption on top of that, which, so it didn't even apply the presumption correctly in the
But I
old
just
rate.
want to make sure I understand. So here, that ratio is 1.25. I mean, is that accurate?
That's the bond, what Denton's bond states.
Okay, so if the prior RFP applied under normal circumstances, you would take that 1.25 and add 0.25.
Correct.
But that's rebuttable.
It's rebuttable, correct?
Rebuttable, what sort of evidence? I mean, would it be the same evidence of what the bonds were, or are we talking about?
Evident, sorry, evidence that that ratio would be unreasonable. So evidence.
Evidence from other rate cases indicating that you don't need that much. in
Correct.
Today's markets, whatever.
Correct, Your Honor. So just any evidence about that utilities finances or comparing other utilities or something showing that that ratio would be unreasonable.
I mean, isn't that the case always before you add the 0.25? I mean, isn't that the whole ball of wax that both sides come in and talk about what the ratio should or should not be? Why isn't the presumption of adding 0.25 totally unrelated to that?
Well, I think that's why it's not a significant change, because these are contested cases and there's always back and
Doesn't
forth.
really do any work, basically, is
Uh,
that.
Correct, Your Honor. So it was always rebuttable. Other parties in the proceeding could rebut it, and they weren't entitled to this coverage. And here, Denton's substantial rights were not prejudiced because the evidence in the record shows that if that presumption applied, it was rebutted, and the commission's conclusion at setting the ratio at 1.25 is supported by substantial evidence.
Well, I will agree with you on one thing. It is not worded that way. That's very confusing. So I understand why PUC wanted to change it.
Yeah.
Which leads to the next question. How's that not significant?
It wasn't significant because it didn't change the filing requirements. So that's another point, that the rate filing package isn't a rule. It's adopted under the commission's rule.
Well, but let's hold there for a second, because one of you, it may not have been you, I can't remember, said it's instructions and guidelines. Moment you say guidelines, my antenna go up on an agency, because guidelines turn into rules real quickly. So it's a guideline, right? It's not a instruction. It's a guideline. You get 0.25 above your proven rate.
It is instructions. The commission's rules allow it to adopt these, but it has the procedural rule for the standard forms. It also has in Commission Rule 25.192, which is the transmission rate rule that provides it will adopt a rate filing package explaining all the additional expenses and how a rate application would be filed. But Denton also hasn't alleged that this rate filing package is a rule. He did here saying it was a rule, but they haven't argued that
So you
this was
disagree-
a
you
ad hoc rulemaking or a.
You disagree with Mr. De La Fuente that this isn't, so I guess you're saying it really is a 2001-038. They would have to bring that to complain about informal rulemaking. You disagree with him that the statute kind of accepts from that because it's a significant standard, and if it's significant, then you have to have notice. Or is that what you're saying?
To the extent he's now arguing that it is a commission rule, he would need to make a rule challenge on this rate filing package. The binding effect of it is the commission's 22.80 says that applications filed with the commission must comply with all the matters designated in the form and substantially comply with the form. So that's just saying that these applications are the applicants, the utilities have to comply with these.
Can I ask a follow-up on that? Like, I know in your brief, you've also argued that even if they're right, and you were to go under the old RFP, you still win. Or what is the case that lets us I feel like, this could chart a bunch of different directions depending on which path you take. What is the case that lets us say like, okay, well, we'll just pretend they did it under the old RFP?
There's the City of El Paso case, which is the commission is the judge of the weight of the evidence and can select from within a range of reasonable. I believe you're asking maybe more specifically about prejudice, whether there. So I did cite a case in my brief.
But it's the prejudice analysis.
Yeah, so it'd be
Okay.
the prejudice analysis. So even if the commission makes an error, if they're not prejudiced by that error, as in the substantial evidence supports their conclusion, then the court should affirm the order. So the court, under substantial evidence, reviews the record as a whole and can affirm on any basis available in the record, not necessarily the basis that the commission relied on.
Do you
So-
agree that an $8 million difference is prejudicial?
The eight, so no, so that was the ratio, compared to their 1.75. No, the commission concluded that the 1.25 provides it with a reasonable rate of return. It was $11 million, I believe, annually is what the commission granted it.
Right, but isn't the standard for prejudice assuming that the other side's argument is correct and that the commission erred, or that there was not substantial evidence because of an error of the law in this situation? That then you look at, if that's correct, then were they prejudiced? In other words, we're not just saying, okay, there's substantial evidence to support what the commission thinks, therefore there's no prejudice. That can't be the standard, can it?
So no evidence supported Denton's request of 1.75. That's Denton never requested 1.5, which is what it's now arguing it was entitled to under this presumption. It never argued for that ratio with the presumption under the old rate filing package. It always argued for this larger 1.75 ratio based on a city debt management policy and that incorrect reading of the presumption.
But this
So
is where I feel like the briefing and the arguments are just two ships passing in the night, because I hear what you're saying. I don't disagree with you necessarily as far as it goes, that you're saying the debt amount is 1.25 and nothing supported 1.75. But then what they're arguing is, and I can see their point, there's an additional 0.25 presumption over whatever's found. And you have to rebut whether that presumption applies or not, and that's different. It's what they're arguing. Therefore, if they proved 1.25, they get 1.5.
no, that wouldn't be how so the presumption was as like a baseline, as giving instructions on when you file the application. It did not add an additional 0.25 on whatever the commission granted to a utility. It was as stating when the utility files an application, this would be a presumed reasonable request. And then you have the contested case where it's rebuttable and they fight back and forth.
What did it say? 0.25, presumption of 0.25 above what?
The ratio in the bonds.
Exactly, which is 1.25.
But that would be, I mean, it sounds to me like if you if you say, okay, we're gonna presume 1.25, then the people that think are an additional 0.25, the ratepayers who think that's too high, they're gonna say it should be lower. And the providers who think it should be higher is gonna bring in evidence that it should be higher. And the only time your presumption applies is when both of them agree that's the right number. In which case, it seems to me, if that's all the presumption was doing, applying when nobody complained, it's not a major significance to take it away.
I agree with you, Your Honor.
I mean, maybe
But where
I'm
does it
just what it
state?
sounds like.
What,
It-
well, okay, I understand what it sounds like, but what does it say? Does it say that?
The exact
Because
wording
like-
of the
Because
presumption.
look, this isn't normal evidence. This is an administrative agency, and administrative agencies, all that matters is what's said. You're constrained by what's said, not what we assume, not what might happen in a normal case, not what might happen in a regular trial court. You are constrained by what's said. So what's said?
The specific language of the presumption in the rate filing package. I don't have exact word for word, but it was that the ratio in the bonds and an additional 0.25 would be presumed reasonable. And I am out of time. I did not get to the general fund transfer issue. I will stand on my briefs on that issue. It was not a transmission expense item. It was an additional return. And we request that the court affirm the final order in full.
Thank you, Mr. Pratt. Mr. De La Fuente, 10 minutes.
Thank you, Your Honor. And I actually got notice I'm going to say hello. So, you know, my children are studying overseas right now. There are people in the United Kingdom and Germany watching this argument. So the state of Texas is on
Oh,
display.
my goodness.
Let's be on our best behavior. everyone.
Right.
Um, Justice Field, you asked the exact right question. There was some dispute about what the base number was. The PUC is arguing that base number is just 1.25, what was in the bond covenants. We believe that the base number was 1.5, and that's the case we put on, because what the RFP said, what the rule said is that you look at the bond covenants and the most recent action of the rate setting authority. Here, DME does set its rates. The PUC reviews and ensures the rates, but the city had a policy of 1.5. So we put on a 1.5 case and asked for 1.75 because the 0.25 presumption exists. The dispute was about the 1.5 case. No, there's you only get 1.25. The most you could support is 1.42. There was no discussion of the rebut that this presumption shouldn't apply. And that's, you're right. There's ships passing in the night here. Why would we put on evidence as to the presumption when there's been no evidence that the presumption's been rebutted? We were discussing the base number to which the presumption applies. And so that's a math problem that again, once you start changing the rules like this is how you end up in the pickle. You know, I do, you know, what Mr. Pratt said about coming because your rates are no longer just and reasonable. One, that's not what they said. They called us in for over earning. And this is the problem. They're right. Financial conditions change, et cetera. I have a home mortgage at 3%. You can't get that today.
No.
Great.
Yeah, I mean, it's nice, but you can't get that today. But if you called me in and said, you know, but that's too favorable, I'm going to put my thumb on the scale, and I actually think I know the market rate's 6%, but I'm going to make it 7 for you because you've had a sweetheart deal for the last few years. That's not how it works. You apply what is a just and reasonable rate in the lanes based on the facts of that case, nothing prior.
Well, I'm totally changing gears a little bit.
You bet.
Why does TOMA matter? I can't figure out in the briefing why TOMA violation matters. If this is a substantial change, they had to give notice. And I assume that's separate and apart from an open meeting notice.
Yes, but again, Your Honor, they blew through the stop sign going faster than the speed limit. We've written them a ticket for both. So yes, they violated their own rules by not giving notice, not publishing in the Texas Register. It's a substantial change. But secondarily, or frankly, in parallel, they also violated the Open Meetings Act because the way in which they changed it was at an open meeting off the cuff.
I see. So two separate reasons to get to the same place.
Yes.
Okay.
Yes.
Okay. I was reading your argument to join those two. So, okay.
Well,
What do you make of the argument that if it was a substantial change and they didn't dot their i's and cross their t's, that this goes back to the commission?
I think the real practical answer, and you know, I know if I'm sitting in y'all's chair, I'm like, well, if I rule the way Joe wants me to, which you should, what's going to happen? And I think remand is right, but it's remand for consideration under the actual rate filing package that is in effect, based on the evidentiary record that was presented, which as the evidentiary record presented does not contain any rebuttal of the 0.25. Then as y'all know, there's separation of powers. You don't tell the agency what they have to rule. You tell them what they can't do, what they must consider or not consider. And in this case, it's under the old rate filing package, and there's no evidence in the record rebutting 0.25 presumption. Now, does that mean they could come back and say, well, the evidence supports a 1.25 base or 1.42 base or something else? They might. And then apply the 0.25 adder, which, by the way, is exactly what the Travis County Court did mathematically when it found that the RFP had been improperly amended. It said 1.5 is the appropriate rate. So, oh, I thought I had another question. You know, you used also something, Your Honor, you talked about guidelines, you know, that the RFP is just guideline, you know, maybe we use guidelines and that starts raising the flag. And I mean, it is a distinction that is different than the one from Pirates of the Caribbean, where, the pirate code's not rules, they're more guidelines. This is not a file 3 copies instead of 2, or make sure you include this thing in your package and not that, which if it isn't included, we'll say you need to supplement. It changed the burden of production and persuasion, and thus had a material evidentiary effect with a real dollar effect on real ratepayers, and by the way, on real citizens within Denton. Let's not overlook the fact that the Supreme Court's made it very clear that a city does have a right to a reasonable rate of return. The debt service coverage ratio is about bond covenants and preserving the city's financial integrity. The bond covenants don't just say 1.25, by the way, they say at least 1.25. The more of a debt service coverage ratio you have, the more reserves you have tied to your debt, well, the more creditworthy you are. Remember when I didn't have any money? My interest rates were higher. The more creditworthy you are, Mr. Pratt made the point, the city does have a significant amount of debt. There's an irony here of by impairing the city's creditworthiness, the cost of debt service will go up, which is a straight up expense, is the multiplier that you use, and eventually our rates are going to go up. I mean, it's really kind of a self-defeating strategy, even by the PUC, if that's their strategy. But, that's a nice policy argument for the pink dome someday. Here, we also, Your Honor, and I think you have a question, we don't need to proceed under 2001-038 because of what it is and how and when it was applied. It was applied ad hoc in the course of issuing a final decision. The path in front of us is an administrative appeal.
That was a question I wasn't sure about. Are you under a duty at that point? Hold the phones. We have to file a 2001-038 action real quick.
Right, and you're not. I mean, 2001-038 is not an exclusive pathway jurisdiction sort of thing. I mean, if you've
more a way to get around the immunity and get you an injunction.
It's a timing thing, and I mean, I've filed some 2001-038 cases, and they're, when the yellow flag goes up and we're in trouble here. This was late in the game. This was, right at the, I mean, as the evidence submitted, the case was decided, and the commission set a standard in violation of the law. There was no rebuttal of that presumption. The commission also set this directly tied standard as to the general fund transfer. And it's really important that exists. Well, it's out there where the leprechaun is.
Well, Dave said it's not a transmission expense, and your point is it is an expense.
In asking that question, you're applying a standard of it must be directly tied. The general fund transfer must be directly tied to transmission. The city of Denton set a policy. We require a general fund transfer of X. DME has to follow that city policy. The city decides what the purpose is. The PUC can examine the reasonableness of the amount, but it never did an amount reasonableness analysis. It did only a purpose-based analysis.
How do you know? I mean, how does a PUC know if the amount is correct without looking at the purpose? I'm confused by that.
Well, the only purpose it can look at is it a general fund transfer? In other words, is this a government code 1502.059 general fund transfer, which the city decides the purpose of? If the city said 100% general fund transfer, I strongly suspect we'd have great case law out there on the commission saying, we've examined, the evidence is general fund transfers in the state of Texas these days range from X to Y, based on these other factors, it should be somewhere in that range. That's not what they did here.
So really, y'all's argument is they can set it wherever they want to set it. If it's within a range, then PUC has to approve it.
If there's evidence to support the range the PUC sets it at. And that's where we get to the second problem here. Because first they decided we're going to exclude this component altogether because of purpose. The second problem they have is all the evidence on that additional portion of the general fund transfer is that if this were an IOU, it would be something greater than zero. All evidence is that it would be something greater than zero.
It would come with 3.5%.
Historically, it had been 3.5. There's certainly evidence of 3.5. There is zero evidence on reasonableness supporting a zero additional general fund transfer.
Thank you, Mr. David Wente.
Thank the court. Always good to be here with our friends.
Good to see you. And Marshall will adjourn the court.
All rise.
Thanks to all of you for traveling.
15th Court of Appeals now stands adjourned.